Good morning. We're still waiting on a few more attendees and we'll begin in just a minute. All right, we'll go ahead and get started. Well, hello and welcome everyone. Thank you for your time today and joining us for social media in the workplace. I'm Leah Strevel, marketing specialist here at Innova. Innova is a national employer solutions company headquartered in Nashville, Tennessee. Through our payroll, HR, and benefits offerings, we support the people who recruit, hire, pay, and empower employees every day. Visit our website, innovapayroll.com, for more information. For attending today's webinar, you'll receive a certificate with the activity ID for 1 hour SHRM and HRCI credit. You can expect to receive those by the end of this week. During the webinar, please feel free to submit questions at any time through the Q&A widget at the bottom of your screen. We will get to as many questions as we can, and if we aren't able to answer them, we'll be sure to follow up afterwards. And now, I'll turn it over to our presenter Angela Kennedy.
All right, awesome. Thank you so much for that nice warm introduction, Leah. And again, welcome everyone today on this Wednesday, and thank you so much for joining me to talk about social media and the workplace. So before we begin, I would like to introduce myself. My name is Angela, and I have over 8 years of human resources experience in the legal field, television production, and the hospitality industries in an HR capacity. I also have my PHR, and I'm also a certified federal investigator for claims of EEO discrimination, as well as a paralegal certification. So as a reminder, as Leah just mentioned, again, you can type questions in at any time, and then we're going to answer them during the Q&A session at the very end. So without further ado, let's go ahead and get started. All right, so in this session, from our agenda, we are going to be talking about the very tricky and ever-changing social media landscape. And when we're done, you'll hopefully have a better handle on how to navigate the laws and apply best practices and the tools you'll need to create your very own policy. Now, I also hope to amuse you with stories of my own so you can see these best practices and policies in action. So the laws and regulations that we're going to be going over today include the National Labor Relations Act, state-specific regulations, and harassment as it relates to social media. So a lot of the content we'll be going over today will be humorous, or again, my poor attempt at humor, as I feel it's easier to remember important content when it's associated with stories. However, it's really important to take the regulations we'll be reviewing very seriously, as the information we'll be discussing is truly in your best interest as the employer. So for those of you whose ears may have just perked up by my reference to the NLRA, or National Labor Relations Act reference, I want to take a moment to inform you that the regulations we will be discussing today apply to nearly all private sector employers. So you've likely heard reference to both the NLRA and the NLRB, the National Labor Relations Board, that provides oversight for unions. However, as I just mentioned, we'll dive deeper into this shortly, but I do want to note that these regulations apply to both union and non-union employers alike. So before we get into the current state of the union of social media, let's talk a little bit about the past. All right, so what is all this about? Section 7 of the National Labor Relations Act. The U.S. is the only country we know of where at-will employment is recognized. And in the rest of the world, you can't fire an employee on a whim. Elsewhere, you have to have really, really good cause, jump through an assortment of hoops, and then you have to go through a really lengthy service period, right, to that employee, and often provide a hefty severance package. So obviously, we operate very differently here, and employers have almost unfettered rights when it comes to altering the employment relationship. However, despite our anything goes attitude, there are a few reasons for taking adverse employment action, whether that's transfer, demotion, or termination, that will get you into trouble. And one of the reasons is because an employee exercised their rights under Section 7 of the National Relations Act. Now, we're going to be getting into all this detail throughout the presentation, but the most basic explanation is that Section 7 of the National Labor Relations Act, or the NLRA, is really applies to all employers and protects certain employee behaviors. So when employees bring their cases against their employers for violation of the act, those cases are heard by the National Labor Relations Board, right? So before social media became a commonplace in employment issues in the employment environment, it was a bit like the wild, wild west. Employers could, and many of them did, discipline and terminate with impunity based on their social media postings. And at the time, this was presumed to be permissible and seen as a common practice when employees were caught griping about their employers on Facebook and other social media sites. But around 2010, social media started to really take off. And as a result, so did the number of cases the National Labor Relations Board was hearing that related to social media. So as the rulings started coming down, we discovered that they were very employee-friendly, which changed the way employers needed to think about and act on social media postings and online between employees. But there is some good news for employers. The members of the board are appointed by the president. So in the last 2 years, it's had several new, very pro-business appointments. And they're starting to change their tune, at least in respect to how policies are written. So there hasn't been much high-profile or really juicy social media rulings yet so far. We really don't know how much they'll come around on this particular issue. And the law itself is unlikely to change, and we know that social media isn't going anywhere, right? So this will be an area of interest for the foreseeable future. So the cases we're going to be talking about in this presentation for today are more from the employee-friendly board. But again, I just want to really caution here, before we start seeing new rulings from employers, we want to assume, and we should assume, the board will continue this pattern. All right, so let's look at some famous social media terminations. To get started and to get a better feel for the issue, now let's look at a few famous, or rather infamous, terminations. Now, just as a side note, I've heard just from the chat that there might be a few, some slightly issues with sound, so bear with me as we try to adjust that just a little bit. All right, so, but if there's any issues with sound, please let me know. All right, so the next one is going to be, first, the unfashionable pizza uniforms. A fashion-forward server at a pizzeria was concerned that the new uniforms weren't exactly flattering. And among other choice descriptions, he said that they made his small frame look tinier than it was. And he wasn't shy about expressing his opinion here. Furthermore, he took his opinions one step further and told his employer in a tweet to its corporate Twitter account, "Black button-ups are the lamest bleepity bleep ever." So after seeing the unfiltered, strong language filled tweets, the employer moved to terminate the employee. And here's another interesting situation. Let's talk about the female programmer who publicly shamed some tech conference attendees online. She overheard 2 male developers making jokes during a tech conference that she felt were sexist. So uncomfortable with confronting them in person, she instead tweeted a photo of the 2 of them with a mean caption to shame them publicly. Her employer moved to terminate and stated it was because of how she reported the conduct. They said to her decision to tweet the comments and photographs of the 2 developers, cross the line of business ethics. Now, let's go ahead and reflect here for a moment. What do you guys think? Were these terminations justified? Or do you think they were legal? What would you have done in these situations? Would all of these employees have been terminated, disciplined, or would you just let some of these postings slide and let it go? Well, I don't want you to worry because both terminations were illegal because they were in response to activity protected by Section 7. Yep, that's right. Believe it or not, both of these situations on the previous slide were an example of the employee engaging in what is considered protected activity under section of the National Labor Relations Act. Now, we'll talk about protected speech in much greater detail, but for now, each of these employees was basically discussing the terms and conditions of their employment, which is expressly protected speech. So, an employee's opinions about uniforms, customers, and coworkers, while they might be rude, are an employee's right to express in the current legal landscape. Now, I know this might be surprising to you, but recent rulings have indicated this and will remain an extraordinarily, or again, at least for the near future, extraordinarily employee-friendly area of the law. So it's important that you're aware of the risk in making any employment decisions based on social media content. And making good decisions based on best practices and the legal landscape is why you're here today, right? So let's take a look at the regulations in greater detail. All right, concerted activity. You're like, Angela, what does that even mean? Well, don't worry, we'll get there in just a moment. To further understand the rise of more employee-friendly regulation, it all begins with a series of origin stories. So let's talk about the Hispanics United of Buffalo. The board found that an employer unlawfully terminated 5 employees who had engaged in concerted activity while posting comments on Facebook about criticisms they had received regarding their work performance. An employee was employed by the Hispanics United of Buffalo, and she believed that some of her coworkers did not provide timely and proper service. And she reportedly intended to basically, pass along their work habits to the executive director. So upon learning of this intention, 5 of the coworkers she intended to discuss with the executive director began to post messages on Facebook using their personal computers, objecting to her opinion that their performance was poor, and they made comments such as, oh, I've had about enough of this. Oh yeah, tell her to come in here and do my bleepity bleep job if I don't do enough. So the employee then demanded that the colleagues stop their Facebook messages and complained to the executive director about the Facebook postings, which she felt were inappropriate and bullying. So the next business day, following the online postings, the executive director terminated all 5 colleagues who had posted on Facebook, asserting that their conduct violated the employer's zero tolerance policy prohibiting harassment and bullying. So, for those of you out there might think this is a legitimate termination, right? Well, the board didn't agree. The board found that the coworkers had engaged in concerted activity by discussing the terms and conditions of their employment for the purpose of mutual aid or protection. And it found that the coworkers were taking the first steps towards taking group action to defend themselves against their coworkers' allegations. Now, although the employer argued that basically they were entitled to terminate the colleagues for violating its zero tolerance policy, the board, citing prior board decisions, stated that even legitimate concerns to prevent harassment do not always justify policies that discourage employees in their exercise of their Section 7 rights. So, you might be thinking right now, all right, Angela, what does this mean in plain English? Well, basically, they found that the posts were not harassing enough to lose protection of the act because, 1, the posts were not made at work or during work hours. 2, they were related to protected criticism of the employee's job performance. Several of the posts didn't name names. And 4, although some of the language might have been harsh, it actually didn't create an intimidating or like legally hostile or offensive working environment. So subsequently, the board ordered the reinstatement of all 5 employees. Now just take a moment and really think about that for a second, right? Can you imagine terminating 5 employees and then you, as the employer, being asked to reinstate all of them? So that's why it's so important to have an expert, an HR expert or professional in your corner. And that's why they can help you understand when an employee has crossed the line from this protected activity to actual unlawful harassment. And that line, honestly, can be really, really hard to assert, right? Without a thorough knowledge of Title VII, which protects against harassment in the workplace, and Section 7, which allows employees to engage in protected activity, which we're going to dive deeper into right now. So generally, the Act protects the rights of employees to self-organize and bargain collectively. And Section 7 of the Act also protects concerted activity when 2 or more employees act together to protect or to complain about wages, benefits, or other terms and conditions of employment. So this is why it is critical to know and understand employee protections relating to social media before you take any action. So an employee's actions on social media that an employer sees as complaining or bad-mouthing may actually qualify as concerted activity and be protected. So employers often get into trouble when employees complain about their working conditions, such as the break room or the coffee service or the lack of coffee service or the length of their bathroom breaks. I mean, you name it, you've probably heard it all, right? So all of these are examples of protected activity regarding working conditions, and disciplining employees for these activities and comments would be unlawful. So as I just mentioned, and this is a really important one that comes up almost all the time, discussing pay is one component of protected activity and an employee's rights, and therefore may not be prohibited. So many times I see an employer telling their employees that wages are confidential. So in fact, I mean, I just recently reviewed a handbook that spelled this out, like in bold, like a great big neon sign advertising that employers have this unlawful policy. And the reason I wanted to point this out to you is this practice is unlawful, and many employers still engage in it today because they simply do not know that it falls under the protected scope. So there's so many pitfalls in this area of law, and we really want to be able to help protect your organization from these nuances that may seem commonplace, right? So the one thing I do want to mention about that, because it gets a little confusing, is that being in HR, or like say having a confidential paperwork of like salary ranges, or someone in payroll that's privy to, you know, all the company's salary history, it doesn't mean that again, and another employee can like question another employee's particular salary. But again, an employee in and of themselves is absolutely free to disclose any information they want about their own salary. So just to kind of clarify that a little bit in terms of some officials or certain individuals within organizations that might be privy to that type of confidential information. So moving on to the like button. In at least 2 similar decisions, the board determined that an employee's use of the like button on Facebook constituted protected activity under the Act. Yep, you heard me right. Just clicking like is protected activity. And although standing around the coffee machine might be, or I really should say like, you know, a fancy coffee machine nowadays, right? Might be an old relic of times long gone by. But it has rebooted itself in the modern culture as the like button, essentially your virtual water cooler. In one example, employees discovered that they owed more in income tax, supposedly because of the employer's failure to withhold sufficient payroll. So when employees complained, the company scheduled a meeting to discuss the issue. And before the meeting, through a former employee, posted the following on her Facebook. Well, maybe someone should do the owners a favor and buy the restaurant from them. They can't even do the tax paperwork correctly. And then a current employee liked the posting. Then the posting then elicited over a dozen comments from current employees, former employees, and customers expressing outrage at the situation and discussing possibly reporting the incident to the regulatory agencies. And then another current employee commented and alleged that one of the owners of the restaurant likely pocketed some of the withholdings from the employees' paychecks. So the owners then got wind, right, of this long thread of postings, and they weren't very happy about it. And they terminated both employees, one for the comment itself and the other for liking the post, which they considered, basically defamatory and disparaging, and in violation of their internet blogging policy that banned inappropriate discussions about the company. So in defending its decision to terminate, the employer argued that by commenting on the posting and liking it, the employee's Facebook activities lost their Section 7 protection because some of the comments contained potentially defamatory statements made by other individuals. But I want to be clarify here, what did the board say? What did the board do? Well, of course, they disagreed. And they held that the terminations of the employees, as well as the company's overall internet blogging policy, were unlawful. So furthermore, the employee's use of the like button constituted protected activity under the Act since he was expressing his support for the concerns shared by others on Facebook. So this board ruling confirms that social media policies and employee usage contain many hidden risks for employers with respect to protected activity. So employers are encouraged to, again, review your social media policies and their enforcement of violations of such policies to make sure you're complying. Fortunately, a little bit later, we're going to be discussing what elements are necessary in your policy that can make sure that you meet these current guidelines. All right. So here's another interesting case involving profanity. An employee complained to the office manager about the employer's compensation practices. The owner of the business called the employee into a meeting and told the employee that he was quote unquote talking a lot of negative stuff, and employee, you're asking too many questions. So the owner told the employee that he had to follow the complaint policies and procedures and that he should not be complaining about his pay. The owner told the employee that he did not trust the employer and that he didn't need to work there. And at that point, the employee lost his temper and in a raised voice started berating the employer with a barrage of profanities that I can't repeat this in polite company for you guys all today. So the employee further told the owner that he was stupid, nobody liked him, and everyone talked about him behind his back. And the employee also stood up in that small office, pushed his chair aside, and he told the owner that if he fired him, he would regret it. So, no surprise, the owner then fired the employee. So the board ruled in the employee's favor because the conversation started as protected speech about compensation, and therefore, according to the board, the entire conversation was then protected. Now, in my opinion, the employer could have prevented this by expressly terminating the employee for violation of its bullying and conduct policies, and then subsequently launching a formal investigation into his compensation complaint and documenting the investigation. Now, there's no 100% fail-safe here, and I am not an attorney, but I would bet that by distinguishing the terminable conduct from the protected speech, the employer could have better protected itself if he was ever challenged with his action. All right, so moving right along into harassment, employers will need to consider two aspects of harassment via their social media policy. First, do you have a legal obligation to address harassment that occurs on any social media site? And two, can activity on social media put the employer on notice of illegal harassment? So again, you're like, Angela, what do you mean by on notice? Well, the law says that as soon as you know, or you should have known, that harassment exists, you have an obligation to act. So this is an evolving area of the law, and it's not entirely clear at this time what your actual responsibility may be, because you have to kind of look at the context of the overall situation, right? So this is just one case, again, from one federal district court, and slightly different factors could always lead to a different result. So while I recommend not seeking out your employees' social media activities, should you be alerted to harassing behavior, you may need to act with a social media policy that will give you the ability to deal with employees who engage in harassing behavior on social media. Okay, so I'll also be giving you a real life story where a client and I had to kind of weigh that risk in determining what to do next, right, based on particular threats. So here's something fun that we're going to move on to next. We're gonna kind of shake things up on this typical type of webinar, and we are going to do a little poll right now, right? So you're going to see, yep, there we go, a little poll that just launched on your screen. So my question is, have you ever had to deal with a questionable social media post made by an employee? Yes or no? All right, so we're going to leave this up for about 30 seconds while you ponder that question. All right, we'll just keep this open for another few seconds or so while you and your team are deliberating on the results. All right, going, gone, and now for the reveal, please. All right, so have you ever had to deal with a questionable social media post made by an employee? So we have a pretty good percentage of you, almost nearly 60% have already had to deal with it. And then we have somewhere around a little hovering over 40% where they haven't quite had that experience yet. Okay, great. Well, we're going to go ahead and close the poll now. All right. Well, that's a very interesting thing, because I will say that even if you haven't had to deal with a questionable post yet, right? Keep in mind a lot of things that are done on social media kind of are still in conjunction with your typical code of conduct policy. So you may have had to deal with something questionable, very similar in that regard, but it just hasn't been in a social media capacity yet. But we're going to prepare you for that day, for the 42% that said no, and for those of you that said yes. We're going to keep the conversation going. All right, so let's start by talking about your Facebook page for a minute and what I would know about you if we became Facebook friends. So based on the information you choose to add to your Facebook page, I would know your gender. I might even know your heritage or your ethnicity. Or if you post pictures of a family reunion or a St. Patrick's Day celebration, or, you know, some type of like Italian American festival, just from a few that I've seen. And I would also know your relationship status, whether you're married or divorced, and if you're a Facebook official with your new partner, or if you're calling it complicated. So if you choose to make your birthday public or post your school graduation year, I could pretty much easily deduce your age. And I might see information about a medical condition, or if there's any posts or prayers for good luck on upcoming surgery. And if you're anything like myself, you probably post pictures of your child, and I would know if you're a parent. So you see where I'm going with all this? All of this is protected information that I would know about you if we were Facebook friends. Now imagine knowing all this about your employees or any potential candidates that are coming in to interview with you, right? It just opens up your organization to so much more potential risk. All right. So in general, we recommend not friending any employees, especially those in a subordinate relationship. And we want to keep the relationship, the employment relationship, separate from the activities outside of work. So organizations can minimize their exposure to claims that the employer made decisions based on any type of protected information that we just kind of went over. Now, if you were ever challenged to prove that this protected information on your applicant's Facebook page was not the basis of your rejection, or similar information was not the basis for discipline for an employee, right? The burden of proof would be on you. to show that none of this protected information was a factor in your decision. So knowing this, do you still want to be Facebook friends with an employee or an applicant? So I generally recommend that employers do not connect with employees on any social media site. Again, it's not prohibited by law. I want to make that very clear. It's not prohibited by law. There's just a lot of risk here. And even if you don't friend them for the same reasons, we generally recommend you don't look at their social media sites at all. So I want to go ahead and repeat that one more time. We generally recommend that you do not look at their social media sites at all. Leave the selection and the employment process to the interview and the employee development cycle, and let that candidate's history and the employee's performance be the only basis of any employment decision. The key here is don't put yourself or your organization in a position where your decisions could ever be challenged. So just again, to clarify, because I think protected information can be a little tricky sometimes, right? Title VII, right? Title VII and several other federal laws prohibit employment discrimination based on, again, the purviews of race, color, religion, sex, sexual orientation, gender identity, age, military status, genetic information, national origin, and citizenship status. And there's actually a bunch more. Those are just one of the most common ones you see on a federal level, but even at your local state level, you may even have a more generous state policy. So here we look at applicants' social media recap, right? So we already discussed you're not going to spend time reviewing your candidates or employees' Facebook status or what gym they're going to after work. And you're not going to allow yourself to be self-exposed to protected information. And we've already discussed that you're going to stay off the internet during the hiring process. And in the interview, you're going to focus only on the essential functions of the position and whether or not the applicant can perform those functions. And also to note here, reference checks are certainly recommended, but the key here is to pick up the phone. The best way to get to know your applicant or your candidate is to talk with them, to interview with them, to bring them in for an interview, as well as any former supervisors or coworkers. So you're going to learn much more through those sources than anything social media could tell you. So keeping in mind some state-specific considerations, since 2012, many individual states have enacted laws prohibiting employers from requesting access to an employee's or job applicant's personal social media account. So at present, there's somewhere around 25 states that have some sort of legislation. And all of these state laws are going to have one common thread. They all prohibit employers from asking applicants for their username, password, or other login credentials for their personal social media accounts. So many of these states also prohibit an employer from forcing employees or applicants to log into their account in the presence of their employer. Additionally, retaliation against an employer or applicant for refusing to grant that access is also unlawful. So let's look at New Hampshire, right? New Hampshire is one example. I like to use this as an example because it has all the common elements that you would see basically in another state with similar legislation. The law protects employees as well as applicants. They, again, request passwords or make them log in your presence, and also or require them to friend you. So you might be sitting there in front of your computer right now thinking, well, that seems pretty straightforward, Angela. But keep in mind, an employer has asked for this in the past in order for this to become the law. So please, for your sake and your organizations, don't tell employees they have to be your friends on social media. So as I mentioned, New Hampshire employers may not require an employee, as we talked about, to provide access to their online accounts, right? Or directing the employee to access the account while supervised, or requiring the employee to make a connection on such a site. Additionally, you're prohibited from retaliating against employees or prospective employees for refusal to provide that access. So with that said, I do want to clarify again, another question that sometimes pops up is that you as the employer absolutely still have the right to obtain information that's in the public domain, right? To collect necessary information for investigations, to act in compliance with state and federal legal requirements or background checks. So this law does not include online accounts directly furnished or required by the employer, nor does it limit an employer's right to limit personal online account use during working times. So again, we'll talk about that a little bit later with the policy, but again, this doesn't prohibit you as the employer to have access to account, like you're asking your employee to create or manage a particular business account or company social media site. That's a different story. All right, so now it's time to get real and put some of this some of this experience and some of these new thoughts here into a practicum and talk a little bit about some real stories from our HR pros. Now, of course, just before I get started, names and certain details have been changed to protect their confidentiality, of course. All right, so we have an employee who's trashing the daycare center on her social media page. I would like to know if we have any recourse against this. Okay, great question. Well, this depends on what the employee is saying. So perceived poor working conditions like hours or the perception of having more, more changing diapers than others or getting enough breaks, you name it, that would likely be, of course, protected activity. But if this employee is making outright false information, well, that certainly could be terminable. So you want to proceed with caution here and making sure that working conditions isn't what's being discussed, right, online. Last night, I got an email from one of our hairstylists saying that the husband of our spa's front desk manager is racist and that she fears for her life. The husband runs a Facebook page full of racist, hateful comments, and she's afraid that the front desk manager feels the same. Okay. So in this case, what's important here is they're indicating the husband, right? The individual with the Facebook page has never actually been to the client's organization or even interacted with any of the employees from the information here, right? Except maybe his wife, of course. So he has not made any threats or communicated in any way with any of the other employees. He simply has a Facebook page with offensive content. So at the end of the day, unfortunately, that's his right. And having a generally offensive content on his Facebook page would likely not constitute a threat to employees or anyone else, however unpleasant the content may be. So furthermore, it would be fair and it would be discriminatory to hold his wife accountable for the content on his page. And we would strongly recommend against this. Now, to be clear, if this individual or anyone else ever makes threats to the employer or the employees, then of course at that point, again, if it was any clear threat, we'd recommend that you contact law enforcement, right? All right, so an employee was on Facebook during working hours, which is against our policy. Remarks that she could have been considered threatening, including one about her manager, help me stay in the seat and not get up, walk across this room and kick the out of her throat. I am too adult for this atmosphere, and this is the most unprofessional place I have ever encountered. I should go slap the HR manager for lying to me in this interview. Please help. I've never had to deal with this before. Okay, so our poor client. Just to let you know, I've really kind of sanitized the quotes here that you see, as they were much more explicit than would have been polite to include in our current company. So basically, you have to weigh the risk here between one, failure to investigate these threats and this act of violence potentially, right? And the recommendation to generally keep social media postings out of any employment decisions. So in this particular case, what really happened is that none of the management team here is actually friends with this employee on Facebook, right? So nobody actually saw, there was another employee who's actually friends with the employee making the threats and brought those threats to the client's attention because she was concerned. So then the client did their due diligence and then investigated those claims. And in the presence of management, the employee who made the allegations voluntarily pulled up the Facebook page, right, and showed them the threats that she'd reported. So then with her permission, the client took screenshots of this. So again, while it's true we generally recommend against making employment decisions based on social media, you have to see if there was more risk associated with failing to investigate, right, and like an OSHA safety duty here, than to act upon a known threat of violence in the workplace. So in my professional opinion, and any neutral third party, and I'm thinking of the board here, would conclude that the client's decision was based upon their zero tolerance policy for violence and threats and their duty to investigate, and not on any other protected information that may have been on the Facebook page. So next one here, and this I am certain if we did have a poll on this question in the future, and maybe we will, but this one here I think is something that most of us in HR have probably experienced at one point or another. One of our managers saw a post on an employee's Facebook page about the employee getting another job offer. This made the manager believe that the employee would not show up for work. Sure enough, the employee did not show up today, and because it's written on her Facebook wall that she accepted another job, if this employee does not show up for work, would it still be considered a no-call, no-show, or is it a resignation? Okay, great question. And I would recommend setting the Facebook findings aside and focusing on the fact that the employee did not show up for work, regardless of the reason that was posted online. The failure to show up to work is certainly a disciplinary issue that the company will want to address, right, in accordance with your discipline policy. Like, what's your policy for job abandonment? What's your policy for excessive attendance issues, right? So the employer should be following the attendance policy and not have to resort to interpreting Facebook posts to determine if the employee is or isn't showing up to work, right? So again, the employer would defer to the attendance policy and treat this situation the same as they would treat any other employee under similar circumstances. All right. So this one here, we don't want employees to be posting on Facebook while we're at work. Can we have an anti-Facebook policy? Well, as an employer, you can certainly hold employees accountable for violating your electronic assets and usage policy. So if you become aware that employees are using the internet to visit any personal sites during business hours when they're prohibited from doing so, you can certainly discipline them. But the key here is we don't want to just have a anti-Facebook, right, specific policy. And instead, we recommend a more general policy for any non-work related sites. And there's a reason for this. In addition to it just being kind of too narrow of a policy, only prohibiting Facebook, it's also because, as we've talked about some other Facebook examples previously in this kind of webinar today, is that employees engage in a variety of forms of protected speech on Facebook. So in addition to posting protected information about themselves, so by having a policy specifically prohibiting Facebook, you might be in a position to prove that none of the protected speech or information was a basis of your disciplinary decision. Also, because documentation is critical, you would also need to time and date stamp the employee's Facebook usage as documentation, right, using screenshots, which would likely then put yourself in a position as the employer to know protected information. So again, there's a lot of administrative burden here in terms of additional high risk. But an employee can always be held basically to accountability anytime they visit an unauthorized site during working hours, including social media sites like Facebook. So instead, what I recommend, instead of an anti-Facebook policy, is a universal electronic assets usage policy that's followed consistently, would be my recommendation. And basically prohibit any unauthorized websites, right, during working hours, and not just social media. All right, so it's that time again. This is very exciting. Now, before we jump into discussing how to create that effective policy, I'm gonna love to hear from you all again, and I'm going to launch a second question. So, I see it here launched on the screen. My question to you: have you had your written social media policy reviewed by an HR professional or employment attorney in the last 2 years? And we have yes, no, and am I supposed to have a social media policy? All right, I'm going to give you guys just a few seconds to deliberate on that. All right, and then we're going to say going once, going twice, and we will now close the poll and reveal. All right, perfect. Okay, so it's kind of, again, a little bit of a split mixed bag here. We have about 52% are saying yes, you have had it reviewed, well done. And about 38% currently no. And another 10% wondering, do I really have to have one? So great. Okay, well, thank you for those wonderful results. Okay, so just to answer your question in brief, as we're going to move into the next section, which is about creating an effective policy, right? Is that, by law, right? Just to reiterate, you're not, required by law to have a social media policy. Just like by law, you're not required to have, let's say, a corrective action policy, right? But you do want to have these things. The reason we have a handbook and the reason we have certain policies that we recommend as HR professionals is we have policies that outline expectations, and then we also outline what the consequences are for violating those expectations. So in brief, if you don't have an actual policy, don't be sweating it out that you have to legally have one. However, as a best practice, and the reasons why we're going to talk about in a few minutes is why we recommend it. And for those of you who already have one in place, great. And for those of you that don't, but are thinking about having ones in the future, this is another reason why this presentation today will hopefully be helpful to you. So even with the new board in place, social media policy should not infringe upon, again, those Section 7 rights. So although the new board might tolerate less blatantly bad behavior from employees when cases end up before them, we certainly would rather stay off their radar. So to that end, we want to help employees think about what they're doing and saying, relative to the company's legitimate business interests. So again, if we're griping about their pay and their hours, that won't really infringe upon the company's ability to function and make money. But if they start tweeting that the company's made a defective product because the employees work such long hours, well, that could hurt sales, of course, right? And give the company a stronger argument for discipline. So to be clear, I'm not saying that's necessarily a slam dunk for the employer, but if the employee's speech could put us out of business, well, that's certainly less likely to be okay. Okay. So after we give, on this next slide here, we need to provide them guidelines, right? Which we were just talking about, expectations, guidelines. So after we give them a basic rule on how to think about their posts, we can provide a little more detail. Our policy has a paragraph on each of these topics and also includes very important language for managers to understand in particular. These guidelines are not infringe upon the employee's Section 7 rights, and any adverse action taken in accordance with this policy will evaluate whether employees were engaged in protected concerted activity. Now, the board's been very adamant that employers should not prohibit many types of activities and language on social media. However, harassment and threats are not protected, right? So employees should understand that if they post lies, half-truths, or defamation, well, that could subject them to personal liability. So one, we want to have something about avoiding harassment, not to use statements or photos or audio that can be viewed as malicious, obscene, or threatening, right? Or with other people of the organization. We want to avoid defamation, which means employees should not be posting anything they know or suspect to be false about the company or anyone associated with it, including fellow employees and clients, and writing something that's untrue, right? Ultimately harmful to any person of the organization is defamation and can lead to a significant financial liability for the person who makes the statement. So, in addition, a company may not prohibit employees from violating policies regarding confidential information so long as the information is actually confidential. So a company can't call all information confidential just to fit it in here. And this section might read something like, employees must maintain the confidentiality of company trade secrets and confidential information. Trade secrets include, but are not limited to, systems, products, and technology. Private and confidential information may include, but is not limited to, customer list, financial data, private personal information of other employees or clients that have not given the employee permission to share. An employee also has the right to determine who is authorized to act as a representative. An employee who claims to be a spokesperson for the company without authorization may be disciplined, right? So that was a bit more specific in terms of what are trade secrets, right? What is considered information that could affect your business company reputation, right? Or your ability to make money. So that's very important. Now, the final thing I want to note here on a guideline is on accounts, which we talked about a few minutes ago in terms of like all these things that, in terms of like, you can't ask an employee to pull up their Facebook page, right? But this very separate piece is on accounts. You can tell an employee not to use company email to personal accounts, that if they're an account manager for the company's social media, they have to make sure they aren't the only person who knows the login and password for it. All right. So just to talk another minute about confidentiality, since this is a topic that the board hears a lot of cases about, during the era of employee-friendly rulings, confidentiality policies had to be very, very narrow, right? And very, very specific. Anything that could potentially infringe on employees' rights to discuss the terms and conditions, could be overturned. But in 2017, there's been more of an employer, I don't want to say employer friendly, but again, it's shifting a little bit, right? So they're taking more of a bird's eye approach in terms to confidentiality and legitimate business interest. So I've seen language such as, any conversations held at work is confidential. That's not going to fly, right? Whether the board's liberal or conservative. So I would just say, take a look at your policy to make sure it's really specific about what is considered confidential, so you could support your demands, right, with legitimate business interest if you were ever challenged. And just to be clear, employees have no greater right to share confidential information through social media than they do in any other format. So the fact that an improper disclosure may occur through a blog or a tweet or other social media service does not exempt an employee for punishment, or should I say discipline, or even potential legal action if they agree to confidential policy or agreement. So there's no get out of jail free card, right, for social media disclosures. All right, so just to briefly talk about a kind of another contrast between two situations. There was one North Carolina employer that operated a line of school buses, right? And they had language in their policy to limit contact with parents or school officials and keep all contact appropriate, and require employees to keep communication with coworkers professional and respectful, even outside of work hours. Now, that was the language that they wrote, right? So the NLRB rejected that policy and said it failed to specify, well, what type of information were they prohibited from posting? And it failed to distinguish between information employees could post or not post. And it also failed to provide examples of social media contact that, well, what is appropriate? What is professional? What is respectful language? What is unfavorable? So what I'm getting at here isn't specific language you have to write down or not write down. But again, as you can see here, just from verbally discussing it, it's kind of vague, right? So keep in mind, you want to be specific, right? What is the specific language? And in contrast, there's a well-known seafood restaurant that also was challenged on their social media policy. And they had language talking about basically how employees could lead to moral issues in the workplace, right? And to prevent that by always thinking before you post, being civil to others and their opinions, and not posting personal information about others unless you receive their permission. So again, this was more encouraging, more specific behaviorals, right? More behavioral things. So the NLRB in that particular case, when they were challenging the language of the social media, focused on the avoidance of morale issues and provide examples establishing the employer was not trying to prohibit on the job related subjects, but rather the manner in which the subject matter is articulated. So is it really a secret? Well, can I keep a secret? Okay, I can't keep a secret. I'm just going to tell you. A trade secret, there may be any type of information such as a formula, device, pattern, financial information, business plan, client list, unannounced products, and so on and so forth. Again, that's kind of a secret. And so while employers may not have the ability to tightly regulate what an employee does on their personal social media account, employers do have the ability to determine how employees spend their time while on the clock. So you can discuss the use of company electronics and company time for personal matters, right? Like social media browsing in your electronic assets usage policy or elsewhere through your handbook. And it may not be reasonable to say you have a zero tolerance policy, but you can certainly say that non-work activities should be limited to break times. Or if you're in an environment where you trust employees to not work things on occasion, but still get the work done, you may want to say something like, keep personal internet browsing, reasonable during work hours. All right, so let's recap today. So one, the things I want you guys to walk away from today's presentation is one, don't prohibit protected activity, right? Employees have the right to post or discuss on social media issues regarding wages and working conditions. We want to prevent bullying and harassment that somehow in today's age has become a forum for all types of bullying and harassment. And employers should be clear in their policy that this won't be tolerated. And comply with your state and federal laws, right? Because you might be one of the 25 states out there that have a little bit of some additional protections. And again, the final step is with any policy, right? We could go through this for an hour and have a wonderful policy, but if your employees aren't educated and your managers aren't educated on what this policy actually means, it won't do as much good, right? So really make sure your management staff understand the elements of what is prohibited and what is, again, complaining about working conditions and wages. All right, so I hope you're beginning to have a really more in-depth understanding of how to navigate the legal landscape regarding social media as it relates to your business. I'm going to pause and take a quick sip of water. I'm going to jump right in for a couple of Q&A questions. And then again, before we end today, we're also going to defer back to Leah. So just give me one moment and we're going to jump into some Q&A. All right, really great. Regarding, can you fire your own employee if they're the ones making racist comments online? Okay, so I'd have to know a little bit more about the circumstances kind of leading up to the social media post in terms of, is this a manager? A lot of times there is some great examples out there where a manager was posting something that would be in direct conflict in terms of like a former police officer or a manager, that the comments that they were making clearly could have a repercussion on your daily operations and in terms of being able to carry out their duties of a manager in terms of dealing with other employees. So potentially, I don't want to say it's a yes, no answer. It really depends a little bit on more specifics. And also in terms of, what is their relationship as a client-facing position where there's a lot of interaction, and is this a company account or is this obviously their personal account? So that would definitely be more of an in-depth conversation, but in general, again, if it's their comments that they're making that could certainly affect the working environment, there is definitely some wiggle room for potential discipline, or again, depending on the severity of the actions or who those comments are being made against, further discipline leading to termination. But again, I'd have to know the specifics without being able to give a clear-cut answer to that one. But that's a great question. So, all right. So one more question. Let's see here. But again, can an employee be terminated for posting negative comments about the company on Facebook, as we discussed? Yeah, I would have to know more about the specific post. But again, if it's protected speech, like a negative comment just again about, the coffee service or the direction of the company, most likely it's going to be protected. But if it's something specific, harassing, representing the company, then that would probably be on a short response, no. All right, so I think we made it into the end today. I just want to thank everyone so much for joining me and for some of the great questions that I've seen. I really appreciate your time and attendance. So we work really hard, of course, so if there's any feedback that we can do to make this experience even more exciting next time, please let us know. And now I'm going to go ahead and turn it back over to Leah.
All right. Well, I'm glad everyone joined us today. Thank you for your time. I know that there were some questions we didn't get to, so we'll be sure to follow up with you separately outside of this webinar. And we also noticed that some people had issues with the polls. They didn't see those. So we'll be sure to follow up with you as well, and we apologize for that. I'm not sure what happened. Please note that as you exit, you'll be receiving a link for a survey in the browser that opened with Zoom. We would love for you to feedback if you have a second, fill that out. You'll also be receiving your certificates with activity IDs for the credit from today's webinar by the end of this week. If you have any other questions about this presentation, feel free to reach out. You can reply by my email. Our next webinar, we're excited to announce, will be June 5th. We'll be covering marijuana and other substances in the workplace. I'm going to post that link right now in the chat. So we hope that you can join us for that. Have a wonderful day.